So good morning, everyone, and welcome to another edition of SMS. So Saturday morning sessions are always enlightening, and it's enlightening because of multiple reasons. One, because of the speakers who are themselves esteemed faculties who are sharing their deep knowledge of GST with professionals, tax administrators, trade bodies. So we have one such speaker today again, Rahul Janji, all the way from Chennai. So he's going to share his knowledge about the JSTAT rules today. And these SMSs are also wonderful because of the participants that we have, all the faculties that are joining from across India and sharing their knowledge, their wisdom of about the practice of the tribunal, whether it's in the CESTAT or the ITAT. So with this brief, I think we'll quickly go to the speaker today and we request Rahul Janji to take over. Rahulji, over to you.
Yeah, thank you, Arudha. I think last week we had briefly discussed some of the rules relating to the manner in which the appeal has to be filed, etc. Today we'll touch upon two very important rules which are going to have a significant impact on how the practice is going to continue in GST tribunal. So the rules which are up for discussion today are Rule 31 and Rule 45, along with the concomitant rules under the CGST rules as well. So before dwelling into the GST rules, we thought we'll highlight the section first. Once again, for the benefit of all, we'll read section 111 of the CGST Act. 111 says that the appellate tribunal shall not be bound by the procedure laid down in the Civil Code of Civil Procedure. It shall be guided by principles of natural justice and subject to other provisions of the acts and rules made thereunder. Appellate tribunal shall have the power to regulate its own procedure. So this is very important in terms of what powers are vested with the authority. The CGST Act has given wide powers to the GST tribunal to function independently. When they say they need not function in the manner laid down by the Code of Civil Procedure, they mean that whatever are the procedures which are followed typically in a civil code, that need not be followed in a tribunal. Tribunal can form its own code. The manner, the functioning of the tribunal can be independently decided by the tribunal itself. So this is very important in terms of how the tribunal is going to function. The act itself mandates that the principles of natural justice has to be enshrined in the manner in which the tribunal is going to function. So wherever required, if there is a judicious view which is required in terms of condemnation, in terms of any latches, in terms of delay, etc., then whatever are the principles of natural justice, they have to be first kept in mind before dwelling into the strictness of the compliance. So this provision becomes very important for the tribunal to overall function in the way in which they want to proceed in terms of the procedures also. Arupta, any points on this? Any discussion you want? We can move forward.
No, I think we can move forward with this. Yes.
Yeah. We'll now come into the rule of today, Rule 31 of the GSTAT rules. Rule 31 deals with the grounds of appeal which can be taken by the tribunal. So we'll first simply read the rule once. Rule 31 says the appellant shall not, except by leave of tribunal, urge or be heard in support of any grounds not set forth in the form of appeal. But the appellate tribunal deciding the appeal shall not be confined to the grounds set forth in the form of appeal or those taken by the appellate tribunal under these rules. Proviso. Provided the appellate tribunal shall not rest its decision on any other grounds unless the party who may be affected thereby has had a sufficient opportunity of being heard on that ground. So this rule is extremely important. They say that the appellant shall, except by the leave of tribunal, heard or be heard in support of any grounds not set forth in the form of appeal. So this prima facie presumption is whatever are the grounds which are taken in the appeal, you have to argue only on those grounds. If any additional grounds are to be required to be taken up by the assessee before the tribunal, you have to seek specific leave of the tribunal. So this becomes very important in terms of what is being drafted in the appeal. If we are missing any factual or legal ground as such in the appeal, it is not the end of the day. You can still request the tribunal. Tribunal may grant leave in respect of any other arguments which are not taken in the appeal as such and take this as additional grounds. Again, if the tribunal wants to decide anything, any matter on any ground, which is not there either in my appeal or by not taken up by the revenue, if it's not present in the appeal, then tribunal has to also provide the opportunity to ask the SC that this is the ground on which they intend to pass an order. Therefore, if there is anything to be submitted on that ground, that can also be taken up. So, Rule 31 substantially has procedural discipline inbuilt by limiting the additional grounds which can be taken. You cannot file an appeal just like that without all the grounds taken. If all grounds are not taken, the tribunal has all the right not to grant leave, not to admit any additional grounds which are taken up in the course of the hearing. Therefore, it becomes really important that when the appeal is filed, as many grounds as possible, legal grounds and factual grounds, are put into place in the appeal itself. Now, is Rule 31 entirely new? The answer again is no. Rule 31 is actually pari-materia, Rule 10 of the SISTAT Rules 82. So, Rule 10 of the existing SISTAT rules also is very similarly worded. Rule 10 says the appellant shall not, except with leave of tribunal, urge or to be heard in support of any grounds not set forth in the memorandum of appeal. But tribunal deciding the appeal shall not be confined to the grounds set forth in the memorandum of appeal or those taken by leave of the tribunal under the rules. Again, tribunal shall not raise decision on any other ground unless the party who affected thereby had sufficient opportunity of being heard on that ground. So, Rule 31 is very, very similar in terms of its application to the existing Rule 10 of the SISTAT rules. So, on Rule 10, there has been certain jurisprudence. I've just put a comparison as such to highlight some of the minor differences. Substantially, the rules, Rule 31 and Rule 10, are very, very similar, but for certain minor terminologies. Rule 31 has been a subject matter, or Rule 10 rather, of the old rules have been a subject matter of dispute. Before going to relations, any points, Arupta, anybody else wants to discuss?
Yeah, and any member wants to take up any discussion on this, because as far as though it's there in the SESTAT rules, as we are arguing, as you all know, as we are arguing the SESTAT, this is not much strictly followed. Unlike the high courts, where the high courts, whenever we take a new ground, it said that where is it mentioned in the pleading? Please tell us the para number. So, like say you are talking about, suddenly in the course of discussion, you become very, aggressive, and you say, my lords, there is a ground of revenue neutrality. So the judges they ask, where is the ground of revenue neutrality mentioned in your pleadings? Please show. But that is absent in the SESTAT as of now. But when this rule is there in the JSTAT rules, and as we know, we will be having members from both the sides. So maybe this is something that we need to be very careful about. And I was discussing, as I was discussing with my team members, that now since we have already started preparing for the JSTAT appeals that we have to file, because as you know, once the president is going to have the seat, then it will be almost only within 3 months we have to file all the appeals. So when we are preparing right now, this is the stage wherein we'll take all the grounds, so that later at the time of appeal hearing before the JSTAT, we don't have to cut a figure that, okay, this is not there in the thing. Then we take leave of the bench that, okay, please grant me liberty to add this additional ground. I think that is one important thing which is there out of this particular rule. So any other member wants to add anything, I think? Unniji, Annapurna ma'am, or Vishalji, anybody wants to add anything else? Your views on this?
I think, Arupda ji,
yes,
I think this legal ground can be taken anytime, I think. But I think for that, they will grant us leave. Huh? Legal ground can be taken anytime. That is a general standard rule.
Yes.
There is one substantial difference between the old law and the existing provisions. We'll come to that probably in another couple of minutes. Old law did not have any bar specifically in terms of adding legal grounds, but now in GST, there's a new rule which has been introduced, which was never there in the old rules at all. So probably after these decisions, we'll also touch upon that. That makes this rule much more significant in terms of its application.
Jan Sahab, kindly share your presentation earlier and this also, please, in the group. Huh? Jan Sahab?
Yeah, sure, sir.
Last time, I think it was not shared. Kindly share.
No, I shared it, sir. I shared it in the group last time.
Yeah, just shared. I'll just reshare it again, sir.
Kindly, sir. Both, because your presentations are very value additive.
Knowledge enriching.
Knowledge. Thank you, sir. Thank you.
Any other member wants to share anything on this? So, or else we'll move ahead.
Yeah, I'll probably finish this. We'll
Yeah.
finish rule 45, then 112, and then probably have a much more detailed discussion.
ठीक.
So in terms of rule 10, though, as Arupda had highlighted, there are not many discussions as such. Certain tribunal rulings, in fact, there's a Supreme Court ruling also in terms of its application of rule 10. So first one, very old tribunal decision where the SC on a classification issue took a ground for the very first time. The classification new tribunal was invoked for the first time by the department seeking to reclassify goods under lower duty rate. So tribunal held that new grounds can be raised for the first time in the appeal if it's relevant and necessary for adjudication. Rule 10 permits tribunal to consider new grounds which are not taken. This has been actually held by the Supreme Court in one decision of Toyota Kirloskar. So in Toyota Kirloskar, the SC had submitted a CA certificate for the first time. Second certificate by another cost analysis by another CA was filed for the first time at the tribunal stage. Revenue objected at the tribunal stage, saying it's fresh evidence. Fresh evidence should not be considered at the tribunal stage. Supreme Court held that second certificate was fresh evidence. However, tribunal has power to consider fresh evidence even if it was not a part of the original appeal, subject to giving the other party a fair opportunity to respond. The Supreme Court also held that tribunal should have been given the opportunity to both sides to produce a reviewed evidence, and the matter was remanded back to the tribunal and not the adjudicating authority. So this becomes very, very relevant. There is some Supreme Court ruling as to the admissibility of new evidence in the context of Rule 10. So this definitely can be relied for all our Rule 31 matters also, wherever we are going to take some grounds. Now, the stark difference between the old law and the new law is the insertion of Rule 112 in the CGST rules. CGST rules have now introduced a very, very specific rule as to when can additional evidence be produced both at the appellate authority stage and the appellate tribunal stage. So for ease of discussion, I have just extracted Rule 112. Kindly pardon my formatting. I just added this now. Rule 112 says what are additional evidence which can be produced and under what circumstances can these additional evidences be taken up by the authorities. 112 says the appellant shall not be allowed to produce before the appellate authority or appellate tribunal any evidence, whether oral or documentary, other than the evidence produced by him during the course of proceedings before the adjudicating authority or the case may be the appellate authority, except in the following circumstances. A, where adjudicating authority or appellate authority has refused to admit evidence which ought to have been admitted, or where the appellant was prevented by sufficient cause from producing the evidence which he was called upon to produce by the adjudicating authority or the case may be appellate authority, where the appellant was prevented by sufficient cause from producing before the adjudicating authority any evidence which is relevant to any ground of appeal, and where the adjudicating authority or as the case may be authority has made the order appeal against without giving sufficient opportunity to the appellant to adduce evidence relevant to any ground of appeal. So only in these four buckets can additional evidence be produced at the higher forum. This is very, very important because the way in which the rule is drafted appears to be that unless until I was making available certain evidence, certain additional documents, and that was not taken up by the authority, then such evidence cannot be actually taken up as additional documents or additional submissions at a higher forum. So, in my view, clause A, C, and D are very, very restricted. B is the only clause where we can rely to say that there was some sufficient cause because of which I was not able to produce the documents. Now, what is sufficient cause and whether that will be accepted at the higher forum? This is going to be a very big challenge in terms of how the rule operates. For the sake of completion, we'll read the complete rule. Subrule 2 says, no evidence shall be admitted under Subrule 1 unless the appellate authority or the appellate tribunal records in writing the reasons for its admission. So when some additional evidence is taken up They have to record in writing why it is admitted, and the reason has to resonate with any of the sub-rules which are provided under 1A, 1A, B, C, D. They have to say under which category have they actually admitted the evidence. Sub-rule 3 says, appellate authority or appellate tribunal shall not take any evidence produced unless the adjudicating authority or officer authorized on the behalf of said authority has been allowed a reasonable opportunity to examine the evidence or document, or to cross-examine a witness produced by the appellant, or to produce any evidence or witness in rebuttal of the evidence produced by the appellant under sub-rule 1. 4. Nothing contained in the rule shall affect the power of appellate authority or tribunal to direct production of document or examination of any witness to enable to dispose the appeal. So this rule in reference to production of additional evidence, there was no direct rule in my recollection, either in the service tax regime or the excise or customs regime, which specifically gave very, very limited reasons where additional evidence can actually be taken up at the higher forum. So, Rule 112, just 1 second, I'm sorry. Yeah, Rule 112 as such on production of additional evidence, it sets out what new evidence, etc., can be taken up. So, in terms of its applicability, this is very, very strictly applied. This is going to be giving a very, very tough time in terms of adding altogether new evidences or altogether new grounds which have not been taken up either at the adjudicating stage or the first appellate stage. So, with this, first I would like to get some inputs in terms of its application. Rule 112 is applicable both to matters before the tribunal and the first appellate authority. Because this rule is already in existence, have we faced any challenge of bringing additional evidence, at least at the first appellate authority stage, where the department has quoted 112 and has cited that they will not take any additional evidences or additional documents annexes which have not been filed at the first adjudicating stage? Any practical viewpoints on this?
I don't think any of us have got it as of now. Any view of the house?
Uh,
Good
Rather,
morning.
they asked the additional submission as such in the case of first appeal, and they have never restricted as such additional evidence with the rule 112 as such. Whatever the appeal we have represented, we have never, rather they have said, please give us the additional submission or additional facts or additional evidences rather. So I think this has never has been a limitation till now.
Arunji,
Mostly what we are
practically,
seeing is, sorry, sir, you can.
ma'am, go ahead, ma'am, go ahead, go ahead. I'll speak after you.
No, what we are seeing is usually appellate authority is asking for fresh evidence and fresh matters so as to assume the role of adjudicating authority. That is what we are seeing practically. And one more doubt what I had is when you are saying evidence, do you mean facts or what about other technical objections? Can we introduce technical objections at the second appeal level or first appeal level, which was not taken in adjudication level?
In my view, legal points can be taken even at the Supreme Court. There's no bar in taking a new legal argument as such. When they talk about evidence, evidence should be in respect of facts.
Facts.
Yes.
I was about to share the same viewpoint which Madam has recently shared, that these days what we experience is that in state appellate authorities especially, they travel to some other point. I mean, some other point confirming your demand. Even that was not touched upon by the adjudicating authority, and you have given all the supportings to justify, but they will confirm your demand on some other point itself. Then I think in this particular situation, we can very well take up and say that this was not available at that point of time. Even adjudicating authority has not taken this ground, and to justify that ground, we can bring out additional evidence at the tribunal level itself.
So when
Ruby?
very good point, Ramandeep bhai, कि if the department has also travelled beyond what is there in the original matter, 112 can also be used by us to say that these are additional points which are taken up. So either to rebut that, we can definitely produce additional evidence, or as a legal point, we can also say that 112 also has to be seen in double ways. Appellate authority cannot take new evidences altogether, which was not even there in the first order.
Hello? Aruchi?
Yeah, Arpit, boliye.
See, what I think is that what has been happening from the start in GST, the department is not aware of the provisions initially. And once they start get themselves acquainting from those provisions, they start to apply those provisions. So
Right.
since the appellate authorities are in a nuanced stage and they are having a acquaintance of the previous provision, they are not applying Rule 112. But similar to Rule 112, which is applicable on department, it is also applicable on us. So there might be a possibility in future that whenever fresh evidences are being accepted, the department may file an appeal before the tribunal that rule going beyond Rule 112 and without incorporating the reasons for admitting fresh evidence is being admitted, and therefore the order is invalid. And tribunal in that case may lay down and subsequently Rule 112 would start become applicable at the appellate stage. So in my opinion, these are initial stages, and that's why they are accepting, because they are not having what I would say is not acquainting themselves with Rule 112, and once they start knowing it, they will start applying it. And it works both ways. The department may file an appeal for admitting additional evidence which were not there without expressing any reason for accepting them. So, in my opinion, these are initial days. That's why they are accepting. Slowly, it would be implemented at the appellate stage once the tribunal start implementing it.
Just
No,
to
in fact,
just to add one
no.
single point,
Yeah.
agreeing with Arpit ji, recently my team member who is a chartered accountant was appearing before a state authority, and he asked him whether you as a chartered accountant is also having certificate of practice or not, because
116
yeah. So
authorized
they are
by the-
getting aware. I mean, in that case.
Yeah,
One more
Yeah.
point to
Padmanabhan.
add, someone from our group was saying that additional grounds are also taken by appellate authority. I think section 75 subsection 7 and natural justice principle also restricts that it cannot go beyond the grounds which have been taken up in the show cause notice. So, just a view on that particular point.
100% agree, sir. But point is that whenever you will go for an appeal, you will object this point, but you will also point out the merits point also and to justify that ground also.
But I have a unique situation wherein we were pleading that the reversal under Rule 42-43 was completely done by us, and there are no further reversals to be done. So we had furnished all the evidences and all. Now the appellate authority goes on to find the classification of the product which is exempt, and he finds that that is not an exempt category; it's a taxable category. So what would happen in that case?
Arupji, there is a Calcutta High Court decision on this, that once an authority has accepted that the Rule 42-43 reversal, then they
Yes.
cannot change and go beyond Rule 42-43 and say that classification is the issue.
Now I'm saying here, considering the classification, is it an additional ground, additional evidence, or it is emanating from the original grounds only? Whether he
So
can
it's
say,
altogether new assessment now. Even in our refund, wherever
Yeah.
refund proceedings in the old law were there, Arudha, department used to deny refund saying credit is wrong.
yes,
And then we used to take the legal argument saying that once in the refund proceedings are initiated, in that proceeding you cannot deny the credit. For denial of credit, there has to be a subsequent parallel proceeding.
yes,
Issue a notice saying why credit is deniable, first adjudicate that and then decide on the refund. You cannot in the refund proceeding sit on adjudication on credit. So I think same principle will apply. If classification is wrong, department ought to have issued a separate notice first denying the
he has issued a
classification.
notice, and his view is that we can always enhance the demand, and I'm issuing the notice.
Nahi, I
So,
don't think.
as
So
per my
personally,
as per my
on the
Yes,
same issue,
yeah,
Rule 42 and Rule 43, we
yes,
raised the ground of 75-7. That the issue was on Rule 42-43. they have asked for the reversal, but the assessing authority has observed the supply is not an exempted supply; it's a taxable supply. So he has gone beyond the scope of the show cause notice. He has confirmed the demand on a different ground, and also the show cause notice was issued for, let's say, for 80 lakhs. The demand got confirmed for 2 crores. So we went for writ before the High Court, citing the same 75(7). The High Court set aside the order. Also, it instructed to treat the order as an SCN and asked to file a reply. Again, what we went for writ appeal, challenging the writ order. How can the order be treated as an SCN?
Right.
But the writ appeal also, what I observed from Madras High Court, the Madras High Court is not inclined to buy the point. They are asking you to file a reply, again based on the, including the pressing on the ground of limitation as well as on the jurisdiction, and also on the facts. That is
Ashwin,
what
I think
the,
the
you know,
previous CJ was like that only. All matters before our previous CJ was straight away getting remanded. He was not inclined to hear anything.
I'm saying it is just 2 months back. So right now again the order has been remanded back. I think the order was passed on April 25.
That's what. So we had our previous CJ till June, and now he's gone to
Got it.
Rajasthan.
Rajasthan, correct.
And so
Okay.
previous CJ was like that only. None of the matters, in fact, had any outcome. He was more inclined to remand any tax matter. So again, depends. So the wrong
Yeah. Which forum?
forum was like that.
So now we'll go to Padma. Padma,
Padma has raised his hand.
Yes. I think Padma is being so excited.
Sir, on a ground level, I just wanted to say regarding this admission of additional evidences, what I see in tribunals, basically ITAT and SESTAT, is that the members are usually divided. The judicial members take a broad view. They say that tribunal is a fact-finding authority, so they will be willing to admit the evidences. Whereas technical members or the department members, they will raise a technical ground saying that where is this rule 112? Produce the evidence that you are not able to produce it before lower authorities, all these things. So on a ground level, this is what is going to happen. The judicial members are going to be more liberal towards admission of additional evidences, whereas technical members are going to object it.
In fact, even before a couple of years, I was also not really seeing Rule 112, etc. Now, after at least analyzing this, all legal grounds have to be definitely taken. We keep the annexure or not. As a matter of practice, I have ensured that even at the first or second level, at least pull up all the legal grounds, because if it's going to be a question where the tribunal is going to be divided, you can at least show that, look, legal grounds were taken because of want of time, etc. The time which was given to me was very, very limited to produce all the evidences, and therefore I have taken all legal grounds, and annexures required time to compile. We have compiled and we are submitting now. So even if we are having some ground where we don't have the evidence to back it up, I feel that at least even from now, wherever appeals are filed at the first or second level, we'll have to take up all the grounds at the first stage itself, even if the annexes are not there. So in most of the matters, I think Rupda would also see, we have taken many legal grounds where annexes are missing because huge volumes of data are required to substantiate any point. Especially this 2A, 2B matters, etc. Wherever there are reconciliation issues where large numbers are involved, we don't get CA declaration, we don't get the certificate from vendors, etc. on time. So historically, even in our VAT and CST assessments, C forms, etc. have been submitted right up to Supreme Court. I have taken various cases where C forms were submitted even after 10, 12 years at the High Court level. Surprisingly, some High Courts in Calcutta, etc. have taken position that C form cannot be submitted. After 10, 12 years, they have dismissed the admission of C forms. Some other courts, including some Supreme Court decisions, have accepted C forms even after 15 years. They have remanded the matter. So going forward, for most of our matters, especially where reconciliation, certificates, etc. are to be given, wherever you have not given them at the lower stage, if you are giving it at the higher stage, we'll have to only substantiate saying the time, etc. was lower. Legal grounds were very much taken. Whatever was available on that date was very much given on record. Whatever new certificates have come after the appeal has been filed, that has to be admitted in terms of 112(1)(b), etc. So there was sufficient cost. I couldn't get the certificate on time, etc. Therefore, please take that on record. So key takeaway according to me is take all legal grounds. Don't miss any legal ground for want of evidence.
Rahulji, one more thing is, like in case of this ex parte orders, where they have passed for not personally representing before the authority. So I think at the first appellate authority, based on this 111, I think we can still produce all the documents, and I think 112 will not be a restriction, right?
I think 112(1)(d) itself says where adjudicing authority has made the order without giving sufficient opportunity to adduce evidence. So here we can rely on D and say order has been passed ex parte. I was never given the opportunity. So all grounds have to be taken afresh before the first appellate authority only.
Okay, and even this 111 section also use the principle of natural justice. So I think based on that section 111 and based on this rule, I think we can try out for all ex parte orders.
Absolutely. We'll now also head into Rule 45, which is again very similar to 112. Rule 45 of the GSTAT rules. There is a very, very specific rule which has been introduced on respect of production of additional evidence. So I'll read Rule 45 first. 45(1) says the parties to the appeal shall not be entitled to produce any additional evidence, either oral or documentary, before the appellate tribunal. So 145(1) is very, very clear. Parties to appeal, as a matter of principle, will not be entitled to produce any other additional evidence, either oral or documentary, before the tribunal, provided that if the appellate tribunal is of the opinion that any document shall be produced or any witness shall be examined or any affidavit shall be filed to enable it to pass orders or for sufficient cost, or if the adjudicating authority or appellate authority or revision authority has decided the case without giving a sufficient opportunity to adduce evidence on any point specified by them or not specified by them, appellate tribunal may, for reasons to be recorded, allow such documents to be produced, witness to be examined, affidavits to be filed, or such evidence to be adduced. 2. The production of any document, examination of any witness or adducing of any evidence under 1 may be done either before the appellate tribunal or before such authorities the appellate tribunal may direct. 3. Where the direction has been made to the appellate tribunal to produce any documents or examine any witness or to adduce any evidence before any authority, the authority shall comply with the directions of the appellate tribunal, and after such compliance, send the documents, the record of the deposition of the witness or evidence adduced to the appellate tribunal. 4. The appellate tribunal may on its own motion call for documents, any summon or any witness on any point of issue if it is necessary to meet the end of justice. So Rule 45 again is broadly aligning with Rule 112. It says that any additional evidence should not be produced before the tribunal unless tribunal permits, tribunals of the opinion that is required. So in terms of the drafting, the language appears to be similar to what 112 says. Appellate tribunal has discretion to admit any additional evidence and cause has to be proved. And apart from this, if appellate authority, if the tribunal wants the authority to also reproduce any documents, etc., the authority can also be called for reproducing any documents which have been relied or which are under its possession at the appeal stage. We'll just make a quick comparison whether such a rule was existing in the old rules. Surprisingly, the very same rule has also been present in the CSTAT rules. Rule 23 of the CSTAT rules have the very, very same language. Rule 23 says parties to the appeal shall not be entitled to produce additional evidence. But if the tribunal is of the opinion that any additional documents are to be produced, etc., then it can do so. So 2, 3, 4 are pari materia, same as the existing Rule 45. So though on first blush, it appears that Rule 45 is restricting production of additional evidence. It is not something which is very, very novel or new to GST rules, barring the fact that it is now backed up by Rule 112 as well. Any points, or we can first go into some specific judgments in terms of application of Rule 23?
I think let's go to the specific judgments first. फिर उसके बाद discuss करते हैं.
हाँ. Rule 45 of the in terms of the old rule some judgments I was able to see whether this rule has been put into application either by the ASSI or the department. So in one judgment of the Tribunal Ahmedabad, ASSI had claimed exemption under notification. A certificate from authority was filed as additional evidence along with miscellaneous application before the tribunal. A revenue had objected, stating that such evidence should not be entertained at the tribunal stage for the first time. Tribunal held that both the appellate and department brought in conflicting additional evidence at the appellate stage. When both sides rely on fresh material, the matter should be reconsidered by the adjudicating authority. The appeal was remanded. So here tribunal took a very liberal view. Though department relied on Rule 23 very specifically, tribunal said that because both the parties are bringing additional evidence, let us remand the matter. Then in one more decision of Bharat Bijli, the case was when classification of certain lift components cleared over different points of time, similar to our Acer matter. Revenue had relied on ISI standards and technical literature, etc., to support its legal ground on why the classification merits to be under 8431. ASSI objected, citing Rule 23, saying these were never part of the original adjudicating record. The tribunal said that technical documents were publicly available, shared with the ASSI, and opportunity rebut was given. Such material only helps in achieving a clear and more accurate understanding of the issue. In classification matters, courts have routinely taken up external technical sources which are not even part of original proceeding. So one of the questions which was raised was if any legal arguments etc. are taken, can that be taken as additional evidence? Courts have always taken that liberal position, saying if it's a technical literature and argument, then that can always be forming part of the subject matter of subsequent argument. So with this, I think we'll first discuss Rule 45 in detail. Any comments in terms of how this is going to play out in the tribunal, especially in light of 112 now? Arubda?
So I think it will be very restricted now. So that is again a huge challenge, like keeping up all the evidences. Because there are many things which develop. So what happens is maybe at times we just file the appeal because of time of limitation. File karna hai. Then again we go.
Last दिन client आता है, कल last date है, due date है.
And then we go into and find out all the evidences and all, collate them before the date of the hearing. So in these situations, I think it will be a challenge. Unless and until it's something which is very technical or which is inherently there, bringing out any fresh evidence would be a huge challenge now.
Padmanabha made a very interesting comment saying tribunal is the final fact-finding authority.
Yeah.
That has always been the principle which has been bound by all tribunals. So when they are having the inherent powers vested to establish facts, can department now start citing these rules to say that even though you are a fact-finding authority, you can find facts only which are present at the lower stages. You cannot find a new fact. And if so, you have to give reasons, record it in writing. Like High Court, we are facing a jurisdictional issue always, whether there's a jurisdiction of the High Court to entertain a writ in first place on admissibility.
Yes.
With tribunal, maybe admissibility is going to become one of the key arguments every time we go. The first argument by the department would be on admissibility of grounds, saying you have taken 5 grounds. C and D are completely new. They were never taken up. No additional evidence were taken up. So tribunal should not even hear the matter on grounds C and D. So let the grounds question of law be restricted to grounds A, B, and E. So whether that kind of a challenge is going to be expected, I definitely think so. Especially if the state members are on board in the tribunal.
Yes. But yeah, in the interest of justice, maybe wisdom will prevail and additional evidence will be allowed. So maybe it will be litigated. So that will be the scenario which we see in the future. Like matters going into the High Court saying that, this additional evidence was taken. This should not have been taken. So maybe that is the trajectory that we are going to see in the days to come.
Sir, this Rule 45, sir, this Rule 45 is a bit wider as compared to 112 because their tribunal has been given discretion.
Yes.
So that is a bit wider.
So that's why when we started the discussion, I started with the section. So I'm not even going into the rules. Section 111 itself gives very wide power to the tribunal. It says that tribunal will be guided by principle of natural justice. So this itself gives enough power and ammunition to the tribunal if they want to be very, very liberal. They can always cite 111 to give benefit, saying natural justice will prevail over everything else. So in light of that, they can always entertain a matter. But when specific procedures and rules are set out, it will become a challenge to argue, and then I think High Court practice is going to increase manifold, especially for matters where additional evidence has not been considered. Then every time you go back to the High Court, get a remand, so matters I think are going to have a very, very tough time to get closed, especially on factual points.
Because this is what practically happens. Like we are handling a service tax matter wherein till the first appellate authority, they have not taken the ground of, it was at a part of the agreement only, the agreement between the two parties. So that we have taken in the stat. So now the department is going to argue that this is never taken earlier. So this is again a fresh ground that you have fresh evidence that you are producing. So I think in the GSTAT also that is a challenge that we'll be facing, because at the lower level, maybe the matters will be handled by the client themselves. Okay, and they would not have foreseen this situation, then they would have restricted themselves to the limited evidence they wanted to give to the adjudicating authority or the appellate authority also in many cases.
Sir, on the contrary, if the tribunal starts admitting additional evidence, it is going to be cycle of remands, because any new additional evidence has to be again adjudicated. So it will go
Yes.
back to the adjudicating officer, then first appeal, then tribunal again.
No, and no, I think in the rules only it is laid down that if any fresh evidence is coming, it has to go to the adjudicating authority for his acceptance.
Correct.
I think that is also there in the rules, GSTAT rules.
I think, sir, provision provides that they may remand back to the appellate authority also. So it's not, there is no, again, thumb rule that it will go to adjudicating authority only. Okay. So that is totally upon the discretion and the context. It is whom it is to be remanded back.
No, I'm saying about the fresh evidence that we are producing before the tribunal. That will also be sent to the adjudicating authority for his concurrence, whether he wants to admit those evidences or not. So I think that is again a thing that needs to be seen.
Yes, yes.
Abhi hearing me one more thing is the expectations of the clients that matter will get over in a single or two hearings in tribunal. If these rules are actually put in place, especially if I read sub rule 3 and all, the number of hearings for each matter are going to be at least half a dozen, because they say any evidence not produced, etc. The tribunal will again ask the authority to give reasonable opportunity to examine the evidence,
Yes.
produce any rebuttal, etc. So I think going forward, the number of hearings are going to be a lot for every matter. Be prepared like 7-8 hearings for each matter. Department will keep taking time. High Court jaisa ho jayega, tribunal where nothing is going to get finalized. At least today, when there is a matter in tribunal, I tell the client maximum 2 hearing mein khatam ho jayega. If you are able to argue it in the benches sitting. Going forward, I have a fear that this is going to become like a High Court practice. Be prepared for lengthy days. If it's not remanded, then you are in for a lot of hearings. Time and again, keep going to a tribunal. Jurisdictional issues have to be overcome first, then go into merits, then convince and get an order. So it's going to be a very, very difficult practice in terms of getting orders released from the tribunal. अभी जैसा shortcut अगर रहेगा तो as Padmanabh rightly said, judges will get the shortcut कि anything new, don't come to me, go back to the first authority. Don't disturb me at all. And all these matters are going to come after 10 years, 12 years, I don't know when. So by the time, whether the clients have documents, whether we have documents for remand, how do we prove, all of that is going to be a nightmare. Because I was handling a matter for Asia, demand of 1986 had come up before the tribunal in 2019. So it was 33 years, department took a new argument. We argued to the tribunal, ki, look boss, 33 years, what do you expect? How do I rebut it? So you can't keep remanding. Already there were 2 rounds of remand. I said third round of remand is impossible. Close the matter. Luckily amnesty came sometimes 18, 19. time said finishes off in amnesty, we are not having any additional document. If these kind of additional documents are to be submitted for 10 years, 20 years, I don't think books of accounts are also going to support. But yes, in terms of number of hearings, I think we'll have to brace up for multiplicity of matters at the tribunal.
So yeah, Rahul, in the previous slide, no, this 112.3a only. That's something I was saying, which is something new. Like it will go to the adjudicating authority to examine the evidence or document or to cross-examine any witness produced by the appellant. So how much time he will be taking? What are the grounds? How it will go? So all those things are again.
वही हाई कोर्ट में अभी हो रहा है ना सर, काउंटर बोल
हाँ.
के ले लेते हैं, फिर 4 महीना 6 महीना 8 महीना आते नहीं है. Next day of the hearing they say we want more 2 months more time to file a counter.
Yes.
So that's why I'm saying 6-8 hearings it will go. अब दोगे वो बोलेगा टाइम नहीं है, देखा नहीं, वापस आओ.
My practical understanding is that they will not wait for this report. They will just remand it for fresh adjudication itself.
Directly.
Shortcut.
They will take the shortcut. After 4-5 years, they will start taking the shortcut. 4-5 years,
even now
everyone will
they-
be excited. Even the members will be excited to decide the matters. Once that phase is over, the honeymoon phase is over, then a remand will be the order of the day.
वही है ना सर, अभी there's so much prerogative then with the judges. If you get a bad bench where I remember I used to argue before a bench of Justice Satpathy and D.N. Panda. Oh, Satpathy sir was very, very strict. You don't follow a small procedure, he is going to kill the matter. No remand and all. You have not done it. Sorry, thank you. Your bad luck, go out. If those days are coming back, you get a very, very strict judge, especially in the state side and all. They want to kill the matter. Then they have more ways to kill rather than going into merits. So you are then at the mercy of the tribunal rather than the merits of the matter. Whims and fancies are going to become a very, very big challenge.
Sir, but specifically in the CGST Act, there is a provision that appellate authority will not remand back the matter. No, not
No,
evidence.
tribunal can.
Tribunal
Yeah.
can do. Only the first appellate authority cannot.
First appellate also, I have seen so many matters where they are again sending it back to the authority. Nobody questions. We don't want to challenge it.
They do. In what case they do remand it to the first appellate authority?
No, I've got a matter where on verification of some data, the order just said that you have not submitted so and so data, so they confirmed the entire demand based on balance sheet and all. The appellate authority said let them again verify. They remitted it back. That has happened in some matters. They've taken a very strict call saying, I don't want to spend time in again doing what the adjudicating authority had to do. So let them properly come back.
No, I'm trying to ask a different question. That because provision says that they can remand back the case to appellate authority and or adjudicating authority. Okay, so the question is, in general, what is the practice when they do remand back to the first appellate authority?
See, right now, wherever facts are involved, they remand it to the original authority.
Yes.
Even tribunal SISTAT does
Yes.
not remand it to Commissioner Appeals.
Yes.
So all remands will go only to the original authority again.
Sir, in ITAT, how they practice is if the adjudication is ex parte, they directly remand it back to the adjudicating officer. I mean the assessing officer. And if the first appeal is ex parte, they are remanded back to the first appellate officer.
So concluding thoughts, I think Rule 112, though it's there, we have not
The
read
voice is
much.
not clear, sir. Could you repeat it?
Padmanabha's voice, is it?
No, sir. In income tax, how they practice this, whether to remand back to assessing officer or first appellate authority, is based on who passes the ex parte order. If the both assessment as well as the first appeal is ex parte, they will remand it directly back to the assessing officer. If only the first appeal is decided ex parte, they will remand back to the first appellate officer. That is a practice that I have been following here in ITAT.
Okay. So, going ahead, a couple of High Court rulings I was able to locate very quickly just before the session on GST. So it's not that Rule 112 is completely obvious. There have been certain cases where 112 has been cited by either the assessee or the revenue. So in this Allahabad High Court of Anandeshwar Traders, the court held that the power of appellate authority to entertain additional evidence, there can be no doubt that 112 does not allow for additional evidence to be led at the instance of the respondent in the appeal. In case of penalty or assessment where the appeal may be filed by the assessee alone, correctness of the order is to be tested on the strength of reason given in the order and not on the basis of supplementary or any other material that may be brought on record by the revenue during the appeal proceeding. To do that would be allow the impugned order in appeal to be tested and affirmed on fresh reason existing outside the assessment or penalty. Clearly, this is impermissible in light of judgment of Mohinder Gill. In absence of specific rule of procedure allowing the appellate authority to admit additional evidence at the behest of the respondent, it never can become open to it to confront to the petitioner's evidence and draw its independent conclusion based therefrom. So here in the appeal, department brought some additional evidence during the counter. This court has struck down saying under 112, department cannot bring additional evidence which was not there at the lower authority. So this again is a double-edged sword. This observation though is favoring this assessee in this matter. Same line of argument can also be applied against the assessee if the department starts citing 112. So court has at least given some weightage to 112, saying new facts cannot be brought out during the appeal stage. The GST matter. And then in one more Calcutta High Court in Rakesh Manda, the court said Rule 112 permits appellant to produce additional evidence before the appellate authority under circumstances. 112.4 starts with a non-obstance and provided nothing in 112 shall affect the power of appellate authority to direct production of any document, etc. Therefore, appellate authority has power to permit the appellant to produce additional document which will enable disposal of the appeal. Appellate authority, while refusing to consider documents filed by the appellant, did not assign reason as to whether the documents are necessary for disposal of the appeal or not. So here, within 112, they have given primacy to 112.4, saying that appellate authority has still wide powers to direct production of any document, etc. So under this power, the appellate authority or tribunal can still call for additional documents, etc. to enable disposal of the appeal. So this appears to be some saving grace. If the bench is judicious, they can always quote 112.4 to say that we have the power, we can always direct new documents, etc. Even if the assessee is submitting, and that is not very, very clearly fitting under 1, 2, 3, 4 for disposing the appeal as such. This can be adduced and be granted as an additional document for disposing of the appeal. So 112.4 seems to be a way out for judges to go and overcome ABCD of 112.1. I think with this, I'll conclude my discussion for today. Probably another 5 minutes. If there are any other points we can discuss. The closing remarks or Kuchet.
So if there are any other inputs or views or discussion that we want to have, we can have on this. But now I suddenly remembered when we saw this, one of our appeal matters, actually the evidence was not taken. So it was a matter of the pollution control, the testing certificate. We had got a letter from the state government citing, that you have to charge this much only for the pollution control testing. That was 100 rupees. So we had argued on that ground that State Department only told us to charge 100 rupees. They didn't tell us to charge 118. So how can we do it and all? So we had given the certificate before the appellate authority. The appellate authority decided that it's additional evidence, we will not take it. So once you shared this judgment, now I remembered. So we went to the High Court and High Court said, yes, this can be accepted and taken in the interest of justice. So it was taken finally.
Now, I think as Arpit was saying, as in when the tribunal starts, some clever officers start citing this.
Yes,
this will become a norm. So they also have training. A lot of our members are also very aggressively training a lot of department people. I see a lot of people, Arubda especially, is very, very regular in training all the assessee authorities. So someday somebody is going to cite 112 in some conference seminar with them, and then उनके ग्रुप में उनका भी फैकल्टी ग्रुप रहेगा. They are going to rely on 112 कि हर जगह 112 इन्वोक करना चालू करो. So not long before they start citing all these rules and then start applying it to deny additional documents.
So that's why we have to be prepared. And in fact, what we are feeling is that we have to start preparation from right now, and not wait till when the notifications are going to be in place. Because I'm sure everybody has sizable number of appeals for the tribunals ready for in their office. So all those things need to be started upon. So that's it. 112. Okay. So I think, is there any other inputs? We will take them, or else we'll take early leave from the class today. Jaldi chutti ho jayega, 2-3 minutes. And it's raining in Kolkata. So it's wonderful situation here. So I think I'll just see if Arpit ji is there. Arpit ji is left. So I'd request Ashwin ji today to give you a vote of thanks. Ashwin ji. I think Ashwin is... Okay, Annapurna ma'am.
दे दीजिए सर, दे के खत्म कीजिए सर.
Annapurna ma'am is there. Yes. Can you please give the vote of thanks? Yes.
Thank you on behalf of this faculty group for such a wonderful session. For I think 2 continuous session on a very important topic has been taken by Rahul with his all practical experiences, and members for active participation. And thank you, Arupji, for the opportunity. Thank you so much. I think we learn more with our practical. Thank you once again.
Thank you. Thank you for the opportunity. I look forward to more such participation.
Ekdam. Thank you, Rahul ji. I think that was wonderful. And thanks to all the participants across India for coming out with their views, because this really helps all of us. So looking forward to meeting. Just one small announcement. Next week on the 5th of July, we'll be having the final concluding session of our tribunal. We are also celebrating the GST day, which is on the 1st of July.
GST week.
GST week. We'll celebrate on 5th of July. So on that day, we're going to have a panel discussion between 2 to 3 panelists on the GST procedures. Okay, so request all of you to block your calendar, because it's going to be exciting, because the questions we have prepared for the panelists, those are also exciting. And I think it will be value addition. And thanks to Rahul ji once again. Have a wonderful week ahead. Thank you.
Thank you, sir.
Thank you.